As a proud member of the class of 1971 and a member of the faculty since 1973, I'm delighted to welcome you on behalf of the law school and the classes of 1970 and 71 to this panel discussion on 50 years of women at the law school. 50 years ago, the Vietnam era classes of 1970 and 71 ushered in a bold new generation of women to the law school and to the legal profession. For a lively discussion on how women students, faculty, and alumni challenged barriers to women then and what the future looks like now for women in the profession, I'm delighted to introduce our panelists. The first three I will introduce are my fellow students at the law school at the time who protested in those days when law firms discriminated against women students in on-campus recruiting. First is my classmate and dear friend, Karen Kaplowitz, an advocate for women in the profession since our student days, has worked as a trial lawyer in Los Angeles from 1971 to 1997, and as a business development coach in the years since. Karen is co-chair of our 50th reunion and served as our class correspondent for decades. Marjorie Gelb, co-chair of the class of 1970 reunion and class correspondent, has been a leader in the public sector as general counsel of the California Department of Fair Employment and Housing, as Berkeley's assistant city attorney, and as director and general counsel of the Berkeley Rent Board. Aviva Victorian, also a member of the class of 1970, has been a human rights attorney for most of her career. She was a leading advocate both to abolish the death penalty in Illinois and to institute prison reform, specializing in the rights of long-term prisoners. She chairs an oral history and community development project in northern Mississippi, where she was a civil rights worker in the early 60s. Also joining us today are two of my colleagues on the faculty. Professor Emily Buss, the Mark and Barbara Freed Professor of Law, has been a member of the law school faculty since 1996. She teaches, among other things, civil procedure, evidence, and family law, and she is a leading scholar on how the legal system allocates responsibility for children among parent, child, and state. She was also a key faculty advisor to the Women's Advocacy Project at the law school in connection with the 2018 report on gender dynamics at the law school. And finally, Professor Sharon Fairley is a 2006 alum of the law school. She has taught at the law school since 2015. She was appointed a professor from practice in 2019, and she teaches, among other things, courses on criminal procedure, legal ethics, and public corruption. Before joining the faculty, Sharon had a distinguished career in public service, including serving as general counsel for Chicago's Office of the Inspector General and creating and building the city's Civilian Office of Police Accountability. And it's now my great pleasure to turn the panel over to Karen for a discussion of where we started 50 years ago. Karen, take it away.
Thanks, Jeff. Well, it's a real testament to the University of Chicago Law School that they would invite a group of us who protested our treatment as when we were law students 50 years ago to speak at this reunion gathering. And I, for one, am really proud to be an alum of the law school. I'm proud to be here today. So we'd really like to take you back to the late 60s when we started here at the law school. And I'd ask Margie Gelb of the class of 1970 to help us set the stage, explain the context. Where were we then?
Thank you, Karen. Well, back in 1970, which is really the olden days, before 1970, the law school had between 2% or 6% in every class or in the classes counted by decade, except the decade of the 1940s, where it leapt up to 8%. And that was true all over the country, and partly because there weren't that many women lawyers or many women who wanted to be lawyers. In 67, when I started, I think women lawyers made up 3% of the profession nationally. And I think most of you know the stories that Ruth Bader Ginsburg and Sandra Day O'Connor, Supreme Court justices, could not find jobs when they graduated from law school. And I spoke to one of your graduates from 1964 who told me that when she graduated, She applied at the U.S. Attorney, who told her they didn't hire women, at the Attorney General, who didn't hire women, Public Defender Office that didn't hire women. She eventually opened her own office. So it's not surprising that we started at a very low number. But in 1964, the 1964 Civil Rights Act was passed, and Title VII prohibited discrimination against women in most employment. It expanded and contracted over time. And although the law passed, it passed in 64, EEOC was established in 65, and most people didn't understand what it meant. And at that time, in 67, there were still male and female help wanted ads. Women were still being fired when they became pregnant. Anyone could say we're not hiring women.
Okay, so we have kind of the basic context. Okay,
Yes.
so then your class, the class of 1970, had 15 women, and my class, the class of 1971, had 30 women. What happened?
Well, this was during the Vietnam War, and for a long time, graduate students, there was a draft at that point, which has subsequently been eliminated, and graduate students were exempted, and the exemption stopped in 1968. And because of that, in my class, which started with 150, we lost 50 students, all the men who either found different deferments or joined a service, or for one reason or the other, dropped out of law school. And that continued. And Aviva, you had some observations about that, didn't you? About the effect of the Vietnam War?
I just remember that when we came in, they called us somewhat contemptuously General Hershey's girls. General Hershey was in charge of the draft. And they expected us, by the way, to continue if some of the males had been involved with the various clinics, they expected us to fill their roles. Whatever the men had done, they expected, the particular men had done who were gone, they kind of, at least I got a word that they expected us to fulfill those roles.
So Margie, you when we got there in the fall of 1968, you'd been there for a year, and there was already a Law Women's Caucus. How did that happen?
Well, the other thing that was going on, this was a very, we had the war, we had the civil rights movement, and we also had the second wave of the feminist movement, which is usually dated 63 to 75. And in 63, JFK started a committee on the status of women. In 63, Betty Friedan published The Feminine Mystique. And in New York, the women were starting the movement by trying to put together consciousness raising groups, because women didn't exactly understand what was wrong. They got to stay home or whatever it was. They didn't understand what was going on. So they encouraged women to get together in what we called, at least I called consciousness raising, but I think all over the country it had a different name. And when we were at Chicago, there were just 15 of us. I think there were 6 or 8 in the class I had, very few women law students. We thought we would get together and do some consciousness raising among ourselves. Actually, we invited the support staff at the beginning, because many of us ended up being friends with the support staff. And they came to some of our meetings, but they were mostly working women with families and had less in common with the students. So they didn't want to stay with us. But
okay, so let's focus for the moment on the kinds of barriers. And Aviva, can you share with us, and Margie too, what were the barriers? So we had this large group, relatively speaking, 15 women in your class, 30 women in our class, entering the law school in these 2 classes. What were the barriers? What did we encounter? Tell us about that, starting with you, Aviva.
Well, when we started interviewing, and interviewing law firms who came to the law school to interview, we found things like they would say, well, these labor lawyers that we're going to be coming across, they're like barracudas. That was the word they used. They use very bad language. And you wouldn't want to be in the labor department because you wouldn't want, that is our labor law department, because you wouldn't be able to deal with them. They said some very stupid and shocking things. And I must say, I was somewhat late to the women's movement because I was focusing on race in Mississippi. And I was very surprised, really surprised. And that we took that up with the Law Women's Caucus and figured we needed to do something about it.
And so then what did we do next, Margie?
What we did was we came back with the stories that Aviva's talking about, including questions like, are you married? Are you planning to get married? Are you planning to have children? Women in our firms don't go to court. And clients don't want to work with women. So we developed a form. Everybody filled it in. We collected the forms, and then some of the women, and I think Aviva and Karen, who were among them, went to the leadership of the school and said, you shouldn't allow these people to interview if they're going to discriminate against women by asking these questions.
Right. So we went to the dean of students, who was a man named Nick Fee, who sent some letters on behalf of women to the law firms who were alleged to have acted in some unfair way. And then what happened?
Well, I had taken a course in Title VII. Owen Fisk taught it. And I had also worked at the EEOC in the summer of '69. Remember, it was a very new agency. But they were starting to write regulations about discrimination against women. And I was familiar with the act, and it prohibited employment agencies from discriminating. And I thought that maybe the law school was acting as an employment agency and had the obligations of an employment agency not to discriminate and not to permit discrimination. And
If I can just add, before that happened, I believe that the law firm that Nick Fee wrote to contacted Dean Neal, and he told Nick Fee, he apologized, I believe, to the lawyer at the law firm and told Nick Fee to leave well enough alone. And that's when we got
Right.
Margie.
So at that point, exactly. Right. So at that point, Margie, you came up with this theory that we might have some recourse under Title VII.
Yes, and as I don't remember everything that went before, but in February, early February, 1970, several of us filed EEOC complaints. We filled them out. We said the law school was an employment agency. We said that it had breached its obligation to prevent us from being discriminated against in the hiring process. And we did that, and at the same time, a committee started a dialogue with Dean Neal and other leaders in the law school.
Were either of you concerned that any of us, including the other women who had filed charges under Title VII with the EEOC, would face some kind of retaliation from the law school?
I don't know why we weren't, but I think we weren't. At least those of us who joined in the complaints were not. Now, there were some women that didn't want to join in, and they might have been concerned with retaliation, but somehow we weren't, and it might be because we were not interested really in working for big law firms, other than maybe getting the experience of practicing law before going into something, what I would say, more interesting. So maybe that was the reason.
But also the context was the civil rights movement. Much worse stuff was happening to people in the South. And the trial of Chicago 7 was about the same time. There was a lot of people standing up for their rights all over the country. And also, to be honest, for me, I was stupid. It never occurred to me that anything could happen. I was just going to go forward, full speed ahead. With hindsight, I was wondering what was I thinking. But
Well, we were doing something very lawyer-like. And, here we were law students. We were being trained in this whole new discipline. And what did we do? We didn't protest. We didn't try to shut the law school down. We didn't do marching. We didn't do any of the things that were going on around us. We acted like lawyers. We filed Title VII charges. And then we entered into this negotiation that you described with with faculty members that Dean Neal appointed to try to work something out with us. I mean, that was a heavy dose of acting like professionals at a time of great chaos around us. So, Aviva, do you want to share anything about the negotiation and the process and how that kind of wound itself out? Were we able to negotiate a resolution of our complaints with the faculty committee?
We were not, unfortunately. The and one of the people on the committee was Owen Fiss, who had worked in the Justice Department in Mississippi, also Stanley Kaplan and Bernie Meltzer. And we really, I don't know how seriously they took it, but the difficulty was, or the place where we couldn't move on, was their refusal to say that the faculty would investigate if there was a complaint. They were willing to say that we do not expect law firms to discriminate, law firms who use our facilities for interviewing to discriminate, but they refused. But then what? Nothing. We would make complaints and nothing would happen. They said that they didn't have the facilities to investigate any complaints. And that seemed to be the sticking point.
So our negotiation, I'm sorry, go ahead, Margie.
I was just going to say, in their, not defense, but explaining the context, they didn't really understand the direction Title VII was going in. A friend of mine who was at Yale, who was asked, are you going to get married, and was outraged. I said, why didn't you do anything? Because we did. She said it was a failure of imagination. I think they didn't understand Title VII was going to say you can't ask those questions. That's discrimination. You don't have to do anything more to be discriminating. And so they couldn't think of Harvard said we have a policy against discrimination on the basis of race or sex, and the facilities are available only to employers whose practices are consistent with this policy. And that seemed like a step too far, I think, at that time for our leadership. But within a year or two, everyone understood you had to go a little further.
So what happened after our negotiations broke down?
Well,
first of all, we wrote I think a very good piece called One Step Forward and Two Steps Back, which we were pretty proud of. We got a lot of support from the men in our classes, and ultimately we filed suit.
Indeed. And at that point, what happened? What happened in that court case?
Well, there was a long administrative period. We filed our complaints in 1970. We didn't get a preliminary decision from the EEOC until 72, and then it was reversed. And so we didn't go to court. We didn't have a right to go to court until 1974. And by that point, we had identified a lawyer, Barbara
Hillman. Hillman.
Oh,
Hillman.
okay. Hillman, right. Who I think had graduated from our law school. And
Yes,
she shepherded us. And I think Judy Bernstein from your class, I think, monitored, because by that point, I was a class of 70. I was out of there at the end of May. And most of my class who were complainants were out of there. So I think nothing much was happening as far as I was concerned, but it was going through the court. But it was only, there was a motion to dismiss, and the court decided the decision in 1974.
So, Aviva, do you want to share with us the upshot of this lawsuit we brought?
well, the upshot was that this was a district court decision, by the way, and we neither had the time nor the money to appeal it. Barbara had handled it pro bono, but she couldn't continue pro bono, and we didn't have the money to appeal. And we weren't sure we wanted to. The bad decision was that the law school didn't have to do more than we had asked them to do. The good thing was they said that the law school, in fact, for these purposes, was an employment agency. We weren't sure if we appealed if we'd get a good result either way. And of course, as I say, we didn't really have the funds to appeal. So that was the upshot.
So our case resulted in the first case, to my knowledge, interpreting the scope of the employment agency section of Title VII in a broad fashion. And the law school was held to be an employment agency. But the judge, even though he wrote a strong statement about the scourge of sex discrimination, did not require the law school to investigate, have hearings, and make determinations.
Right.
At the end of the day, we lost on the substantive aspect of the relief we sought. Go ahead, Margie.
I would say that the Title VII decision in our favor, the first one before they reversed it, it said that it almost said harassment, even asking those questions, even treating women differently, that was discrimination. And that should have been enough, but the court did not follow that path.
Right, you're referring to the administrative ruling.
Yes.
Finding reasonable cause that there had been discrimination.
This
Yeah.
was
Under
by
Title
the
VII.
by the EEOC.
Okay, all right. Okay, so I want to keep moving along because, we've gone backwards 50 years and talked about this conflict we had and how it got resolved. I want to just ask you before we move on, Aviva and Margie, what did that experience mean to you? Being in this conflict with the law school, challenging the law school under Title VII and in the courts, what did that mean? Margie, do you want to start?
I went to law school because of the civil rights movement. That's the only reason. That's why I went. And this lawsuit and the way the law school treated us and the way our colleagues treated us, it gave me confidence in my ability to organize and to use my skills to combat discrimination and further social justice. And so when I started practicing law, I was off and running.
All right. Okay, Aviva.
I would say the effect it had on me was a real appreciation for the women's movement. As I said, I was kind of a latecomer, and I was most impressed, not so much with the law school, but with the students, with the women, and I was really impressed with them, and I became a real advocate of the women's movement.
That's great. Jeff, you want to comment at all on your observations from that period of, how the law school handled this situation?
My sense is that the men students were generally supportive and sympathetic to this, and they believed that the law school needed to correct what was going on. And I don't know how knowledgeable they were about what the law school was doing on a day-to-day basis in all of it, but I think those who were closest to the women involved had a pretty clear sense that this was a struggle and that it was admirable that the students were pursuing it.
So I want to say that I, looking back and at the time too, was blown away by the fact that the law school treated us as professionals and with as much civility. So we were making trouble. We were definitely troublemakers. The Title VII charge, the lawsuit. We were not we were problems for the law school. And yet Dean Neal, even though he didn't agree with what we wanted the law school to do to protect us and to protect other women, was a really stand-up guy. And in terms of this idea of professionalism, civility, and I know I personally was the beneficiary of his going out of his way to be supportive of me in my career. I know you've had some experience along those lines of making similar observations, Jeff, if you want to add anything on that score.
Well, one story that I think is very revealing is Roberta Cooper Ramo is an alum of the law school class of 1967. And Roberta has had and continues to have an extraordinary career. She was the first woman president of the American Bar Association in 1995, the first woman president of the American Law Institute, a person of enormous influence and prestige. And in 2015, the ABA held a meeting in Chicago in which they were going to give Roberta an ABA Lifetime Achievement Award. And the night before that event, Roberta and her husband hosted a small casual dinner with some people from Chicago, and they were nice enough to invite me to attend. And they also invited former Dean Phil Neal, who at that point was in his late 90s. And at this point, frankly, Phil was in a wheelchair and was not all there. And at one point, Roberta walked over to Phil and said, Dean Neal, I have to thank you for what you did for me, because you played an absolutely essential part in my career. And without you, I would never have been where I am today. And she then looked at the other people standing around and she explained that in the spring of her third year, spring of 67, she got a phone call from Dean Neal's secretary saying the dean would like to see you. And Roberta was very daunted by this. And this again, is she's telling us the story, that she was very daunted by this, but went down to the dean's office, and Phil's secretary let her in, and Dean Neal said, what's this I hear about you not having a job yet? And Roberta said, well, my husband has taken a job in North Carolina, and it appears that no law firm in North Carolina is willing to hire a woman to work for them. And Phil said, that's outrageous. And he picked up the phone and he called Georgia, the governor of Georgia, Terry Sanford. And in front of Roberta, he said, Terry, what's wrong with you people? I've got this extraordinarily talented woman in my law school about to graduate, and she's going to be living in North Carolina, and your firms will not hire a woman? Yes, damn it, do it. And Phil said, okay, you can leave now. And then Roberta said, the next day I got a phone call from one of the leading firms in Atlanta offering me a position. And as she told this story, everyone was standing there, utterly stunned. And then we looked down at the end of it at Dean Neal, and he was looking down at his lap, and there were tears coming down out of his eyes across his cheek. And it was just such a touching and sweet moment. He passed away a year or so after that. But it did speak volumes to me about Phil Neal and the character that he brought to the law school.
So we had a real clash between the Women's Caucus and the three of us and our compatriots and the law school about what we expected from the law school in terms of how they would intervene and protect us. But I do believe, both at the time and looking backwards, that I certainly appreciated and believed that Phil Neal and others on the faculty had a strong commitment to equality and to eliminating discrimination. there was never, in my view, any sense that, personally or professionally, they set limits on women. They just weren't willing to step up quite as much as we expected at the time to protect us. So I want to jump ahead now about 15 years, Jeff, and you, of course, had joined the faculty in 1973, and then you became the dean of the law school. And you did something, pretty amazing when you confronted discrimination in the recruiting practices again. And we'd love to hear from you what happened then.
So the incident you're referring to occurred in the 1988-89 academic year when a lawyer with the law firm of Baker and McKenzie was interviewing our students. And one of the students he interviewed was an African-American woman. And during the interview, he made a number of clearly racially inappropriate, indeed arguably racist remarks to the student. And it upset her deeply. And it was brought to my attention as dean. And I spoke to several faculty members and certain associate assistant deans about it. And I reported it to Baker and McKenzie. And my initial reaction was to report it to Baker and McKenzie and then leave it at that. But then the head of the Law Student Association that year, who happened to be Lori Lightfoot, now, of course, the mayor of the city of Chicago, came to me and asked me what I was going to do about this. And I told her what I had done. And she said, that's completely inadequate. And she was very adamant and persuasive about the fact that we needed to do more about this. And I was right, she was right. And I then called the folks at Baker and McKenzie, and I told them that they were banned from interviewing at the law school for a year because they had failed, obviously, to educate and to train their own lawyers about the appropriate bounds of the interviewing process, and that unless they put in place a training process, we would not let them return. And I have to say, they were very gracious about it. They thought it was a sensible thing to do. They felt terrible about what had happened. Thereafter, several other major national law schools banned Baker and McKenzie, and a number of other major national law schools also adopted training programs along similar lines. But Lori Lightfoot is the one who really deserves the credit for this. And it's quite wonderful that she's gone on to have the career that she has.
So had anything changed other than the fact that, Lori Lightfoot was a very effective advocate in addressing the issue?
Oh, I think there's no question, but that both among students and among faculty and among alumni, issues of diversity, both in terms of recruiting students and faculty who would be more diverse, and also in terms of even in ways adjusting the curriculum to be more responsive to those kinds of issues. That changed a lot from the time we were students till the time I was dean, and it's continued to change in the years since then. These are issues that the law school and other law schools as well have come to regard as of essential importance. And I do think that we made considerable progress from the time we were students till the time I became dean. Hopefully we made some progress while I was dean, and we've continued to make progress in the years since. When we were students, there was only one woman professor, Soya Menchikoff. And it was interesting how Soya became a faculty member at the law school. Soya was a student of Professor Carl Llewellyn at Columbia Law School. And Llewellyn was one of the great scholars of his generation. And she married Llewellyn shortly thereafter. She became a very influential a lawyer in the field of commercial law. When Llewellyn moved in 1947 to teach at Harvard, Menchikoff became a lecturer there and was the first woman ever to teach a course at Harvard. Several years later, in 1951, Llewellyn came to Chicago to participate in a conference, and he was sitting next to Edward Levy. And Edward said to him, "I think you should come to Chicago and join the faculty here." And Llewellyn looked over at Edward and said, interesting idea. What about soya? And Edward said, we'll take care of that. But then it turned out when the law school faculty voted to give a regular appointment to Soya Menchikoff, the university had an anti-nepotism rule that prohibited any unit of the university to hire both a husband and wife on the faculty. And so Edward managed to create a wholly new title, professorial lecturer, which he in the law school bestowed upon Menchikoff. And she became a full-time member of the faculty with that title. And then when Llewellyn died in 1962, Menchikoff became a full professor at the law school. But diversity was an issue by the time I joined the faculty in 1973. Faculty talked about it, both in terms of increasing the diversity among the student body, increasing the diversity among the faculty. But it's been a long, slow road. But today, we have 15 women academic faculty members out of a total of 42. Not as many as ideally we would like, but an awful lot of progress from when we were students. And a total of 25 women faculty out of 58 when one includes both clinical and academic faculty. And indeed, by coincidence, this year, we added 4 women academic faculty members to the law school, the largest increase in any year in our history.
Well, you knew that we at this reunion would be looking closely at this issue. So you were anticipating that you would be called to account this year.
Of course. And when I was dean, we hired several women faculty members, including among them Elena Kagan, who of course went on to have a fairly impressive career. And it was a high priority for the law school. But it was difficult because there still were not anything like an equal number of women law graduates to men at that time. And the legal academic profession was still not seen as all that congenial for women who saw it as a primarily male environment. But it was something that, again, I want to be clear, the law school cared a lot about, both in terms of the student body and in terms of the faculty. But it was a challenge and continues to be a challenge to this day.
So yeah, go ahead. We'd love to hear from Emily Buss and Sharon Fairley, your colleagues.
Yeah. So I was going to say I should turn now to my colleague, Emily Buss, to tell us more about women on the faculty and about the experience of women students and women in the profession. So Emily, why don't you take it from here?
Sure, thanks. I first of all, I just want to say how much I have enjoyed hearing where things started, how much we can thank you all for what you've done. And I would say the spirit of a well-meaning and committed to a non-discrimination institution and faculty that needs a lot of pushing and creativity and seeing what does it mean to discriminate and sort of seeing the next stage and pushing us further is very much the spirit that lives on today. I think that it was really wonderful to see that capture. And I just have to start with a personal comment, which is I owe a special debt of gratitude to the women of classes of 70 and 71. And I didn't think about this until we started planning this panel, but my father started teaching law school at the University of Iowa in 1967. So his first classes were 70, 71. And he was radically feminized by his female students. And even as a child, I remember the significance for him of how he was pushed by his women students. And it profoundly changed him, clearly as a faculty member, but also as a father. And that, here I am today. I mean, I just want to recognize the linkage and how powerful your experience, I lived it from another point of view, and it was profoundly influential. So thank you. Yeah, I think that there's so much to say. I've been sort of asked to talk about a lot of categories, and maybe I'll jump in with some, and others can tell me what whether I should say more about anything in particular. But I'll start with the students because I really want to focus on our continuing amazing students who continue to push us. So now we have it's roughly half and half now, pretty much every year, women and men. So I think we have a class that's going to graduate in 2020. I may get this slightly wrong, but we have 51%, and then the class that just came in 48%, but we're hovering in the high 40s, low 50s now for the percentage of women. So what does that mean? It means that, the normative male law student, that's just gone. There's no expectation, anything about what we expect to see in the classroom, who we expect to engage with as faculty, and what students expect to see from each other is just, it's really, very, very sort of gender equal. And I think that's really important. In recent years, we've seen tremendous strides in terms of women taking leadership role. I believe the last 3 editors-in-chief of the Law Review were women, are still women. And 8 of the most recent 18 Supreme Court clerkships have gone to women. Still not half and half, but we're getting close. And there have been real efforts by the law school to recruit especially strong women. We have programs that allow for full merit scholarships to try to identify highly qualified applicants that might otherwise choose other of our competitor peer law schools. And we have targeted a lot of that support to highly talented women who might go elsewhere. So, I think all of that is a very, very positive story, moving in the right direction for all the right reasons, and we as a law school have really benefited.
So what happened with the women? Yes, what happened with the women's advocacy?
I'm just gonna say, but we still have a long way to go. And what I really love to think about when I heard about the story from your class is that in the same way, our women law students who were less than completely satisfied with what was happening at the law school, they employed what they learned in the classroom, which is increasingly not just litigation, but also empirical research. And they developed a really impressive study that they broadly described as gender dynamics in the law school, sort of noticing differences in participation rates in the classroom and who was holding leadership roles, and their sense of the overall experience, which of course translates into how you feel going out into the field and becoming lawyers. They said, they noticed, they thought, they identified issues, and so they did this very comprehensive survey that involved massive numbers of classroom observations to see participation levels, a very widely responded to survey of law students, interviews of almost all of the faculty, I think anybody who was willing, and then as well as bringing together data. And they did, I think that the link is available for those of you who are attending, but I wanted to sort of show you the physical copy. They produced a really impressive and comprehensive study of their results. And their findings were, they found some wonderful things, like women, if anything, have more mentors, that they thought there were real signs that the approach that professors took in the classroom had an impact on how much women participated, and indeed having women faculty made a real difference in how comfortable women were participating. But they also identified areas for change, and they focused on the need for supports for more women in leadership roles in the law school. And as I've mentioned, some of those things have, even since 2018, I think, really clearly improved. And they've sort of called on us all to continue to be paying attention to that level of experience and to work on some of the recommendations they made. So it was very, it was done incredibly well. The sort of the rollout, the presentation of their results was well done and well, heavily attended, and it's had a real influence. I think that many people, in having discussions about women's experience at the law school, will refer to this study. And when I want a reminder of what I need to work on or what we need to work on as an institution, I still go back to this really impressive study. And when they summarize, I don't know if I can quickly read a quote because it reminds me so much of what you all said about your own experience. More than anything, however, the study was motivated by a deep love of the law school, respect for the institution, admiration for our professors and classmates, and immense gratitude for the education, experiences, and relationships that we have gained during our time here. We believe that the best way to express that gratitude is to engage with the institution, challenge it, and push it to continue improving. So that is very much the spirit, and it still lives today. Maybe I should say a little bit about the experience with the interview and the hiring process, since that was so much your focus. So that has changed dramatically as well. I think in general, law schools devote many more resources to the support of students. So this idea that it wasn't the law school's responsibility to sort of step in, I think already by Jeff's deanship, but clearly today that sort of no one would think in those terms. But sort of very importantly, I think at the entry level for law firms now, there is, it's gender equal, right? There's no sense that and there's clearly nobody, everybody understands how inappropriate it is to inquire about family plans and the like. That is well understood, starting with the education back in your years. The career services is very focused on individual support. They do individual interviews with everybody in preparation for the job, for the law firm job process, which means they have a chance to hear, what are your issues? Are you going to have issues that you want us to help you sort of look for law firms that are going to be supportive in other aspects of your life? So that is very much how they see their job. I think maybe this goes beyond what we really have expertise to talk about. Certainly I do, but I think the real challenge now for sort of gender equity in the profession is advancement. And that is, there is still, an underrepresentation of women in leadership positions, particularly at law firms. And I think that does tie in with the fact that law firms have not figured out as much as they should, and I hope eventually will, how to be supportive of people balancing serious, ambitious careers with serious, ambitious commitments to family. So I know that is an ongoing issue, and that the career services tries to help people think in the front end about how to manage that. But I think it's still a really significant issue. More of our women than men students identify as interested in public interest, and we have dramatically expanded our supports for people interested in public interest careers. So that is something where I think we help recruit women as law students when we show support and ability to help them placed in jobs in public interest as well. Should I keep talking and talk about faculty, or should we let others get a chance?
I think we want to be sure to hear from Sharon as
Absolutely,
well.
absolutely.
And clearly, when we addressed our issues, it was about women. And our class had 30 women in it, but only 3 students of color. And there were 2 Black students and 1 Native American, but that was it. And if you look at what's happening in the profession, it's pretty clear that we still have a huge way to go to making our profession more inclusive for lawyers of color and perhaps other underrepresented people, but on the lawyers of color front. So I'd be really interested to hear from Jeff and Emily and Sharon about what the law school is doing and how whatever we've done and have done on the sex and women front is now applying to these other issues of inclusion.
So let me jump in there and make a few comments then. So as Professor Stone described, efforts towards creating more diversity in the student body at the law school, were really well underway. Certainly by the time I got there in 2003, those efforts have started to make fruit. I think our class was perhaps had the biggest contingent of African-American students. Certainly by that time frame, there were 17 African-American students in my class, which created, a really good kind of center of gravity for us all. But those efforts are still ongoing. There's still a lot of work that needs to be done to make the law school experience inclusive for everyone. And the law school has really made a number of strides in that area. And Professor Buss has been part of that process as well. There is now a faculty diversity committee that works on these issues. And then we also, just in the last 18 months, we've also hired a director of diversity to help support those initiatives. So the director of diversity really focuses on the student experience and has made a lot of headway in creating programming to make the law school experience inclusive, and to make sure that we're supporting our students of color and providing them the support that they need. And of course, the faculty committee really focuses on the issues of curriculum and pedagogy. There's a lot of work focused on, making sure that we are, offering students the kind of, teaching experiences that they want, by incorporating issues of race in classes that already exist, and then also increasing our academic offerings to address issues of race and race conflict. And so we're seeing some headway there. That being said, there's still a lot of work to be done, as you guys described, the clash between women and the law school during your time there and during your experience. There's still a fair amount of that now between there's still opportunities for clash to happen between students of color and the law school, because sometimes this idea of creating an inclusive environment can create tension with the core value of the law school about teaching freedom and faculty's freedom to teach in the way that they see fit. So that can often happen. The challenge also, as you've also discussed, is that even when students leave the law school, they're entering a profession where women of color in particular are really having a difficult time. And although some progress is made, there's a recent study that the ABA just completed. And when you look at women of color in law firms, for example, the percentage of partners who are women of color is only 3.8% at this point, and that was only up from 1.5% 15 years ago. So the progress that's being made there is really, really slow. And if you look at the percentage that are Black women, it's under 1%. And so there's a lot of challenge. We know that women are leaving law firms for many of the same reasons that women of color leave the law firm environment for many of the same reasons that white women leave the law firm, in terms of, the cultural issues, lack of support, having family obligations. Women of color also have a hard time with mobility in the profession, because they often don't command that book of business that's required to make like a lateral move. So that has become a challenge as well. And then just getting to the third piece, which is faculty and being the legal academy, and the challenges women of color face when it comes to that, front. There's been very little research on, much less research on the issue of women of color in legal academy compared to the law school environment for students. But what we do know is that there are a lot of challenges for women. If you look at progress on tenure, 7 years out from accepting an entry-level position, there's just a huge dichotomy between women of color and their white male counterparts in terms of who's been offered tenure and salary information and all of that. And there are a lot of reasons for that sort of go into that calculus. Some of it is, cultural. Some of it is just the process is just not conducive to women of color being able to succeed. Some of it's the way, faculty are evaluated. And so there's a lot that goes into that needs to be sorted through.
So Jeff, do you want to comment on what you see as the role of the law school and the extent to which you think Chicago is taking a leadership role these days in addressing the issues that Sharon and Emily have reported on?
I think insofar as we're talking about students in the law school and recruiting students and trying to make sure they have a positive experience, I think the law school is doing an exceedingly good job about that. Has created an environment where it's clear that this is a priority for the school. The more difficult question, I think, in terms of the role of the law school, is eliminating the barriers that still exist for women and lawyers of color or other underrepresented groups in the profession itself. I mean, one of the awkward questions there is to what extent law schools should attempt to influence the performance and values and behavior of the legal profession beyond the law school. And that's an awkward situation. I think it's clear that the law school wants to see law firms and government and other employers being receptive and thoughtful about the special challenges faced by women and lawyers of color. But what I don't have a good understanding of, and maybe Emily knows better, or Sharon, is whether the law school is taking any active steps in dealing with, for example, the various employers who interview at the law school to try to get them to be more thoughtful and more careful about these issues. Emily or Sharon,
Yeah,
do
I
you
was
have
gonna
any?
say, the only thing on that issue I'd say is I think the law firm is really helping students be good information gatherers, so that in the extent that they can vote with their own choices, that they're really helping, fortify that decision-making process. So I think there's some kind of I think there is trickle back. I mean, you hear things that law firms know that they have to, they have to care about. And sometimes it's, the first step is just a kind of nice marketing and you wonder if there's anything behind it. But I think our career services is very helpful at helping our students get beyond the marketing and figure out how to really look at a law firm to figure out, how it's handling these things. What kind of support is it providing for women to rise? What is it? How is it responding to issues of sort of managing family life and that sort of thing? Yeah. I mean,
Sharon, you have any thoughts on that?
Yeah, no, I don't have a lot of experience in understanding how the whole recruiting process works, but what I will say is that one thing that the law school does, I think, a fairly good job of doing is bringing alumni of color to the table, and through various, programs. We have the Parsons Dinner. We're having a big conference to celebrate the 100th anniversary of the first Black JD graduate, Earl Dickerson. We dedicated a lot of resources and time and energy around that, and are pulling in community members and alumni to celebrate that. So I think that through working through alumni, the school is helping to promote more success for its students of color as well.
Well, that sounds great, especially because I can tell you, being out in the community, that there is a tremendous battle for talent right now among law firms. The law firms are fighting tooth and nail competitively to attract diverse talent and to retain diverse talent. So that's a huge priority in the law firm community, and they are tooth and nail competing head to head. So to the extent that you are supporting alumni and you're supporting students in being prepared for the incredibly competitive workplace, that sounds really good.
I also think that one of the most productive, uh, situations that's going to prompt law firms to do a better job in this direction is the fact that clients are starting to demand it. So there are clients that have a much deeper commitment to diversity, to all, diversity, equity, inclusion, and they're trying to push that out onto their firms by demanding that they have people of color working on their business, and requiring that to get business. So I think that is a future opportunity to help drive the process a little bit more quickly than perhaps law firms might do on their own.
So before we wrap everything up, I want to just give everybody a chance to make a final comment. This has been a really interesting, stimulating conversation, starting 50 years ago, bringing it up to the present. Can we do just a quick round of final thoughts, starting with you, Margie Gill?
Well, clearly, we have made enormous strides since the dark ages of the 1970s. And I, at least listening to Emily and Sharon, have been very interested to see how Chicago has reached out and opened its mind to look at different places where it can interact with the legal community and the larger community, in the pursuit of justice for all.
Emily, do you want to give us any final thoughts as we wrap up?
Sure. My final thoughts are just a little bit sort of jumping off something that I think Sharon alluded to. I think our big challenge as an institution is figuring out how to really even more comprehensively diversify our faculty, and to figure out a path there. And we have a virtue of being a fairly small faculty, which has so many things that are good about it, but it means it's really that critical mass that you all talked about when you're talking about when you originally started, doing your work. It's especially for people of color, establishing enough of a critical mass that people want to be at our institution as faculty and want to stay is a challenge. And I think that's, what I would say if I put on the top of the list of, where we need to head, where we still have some real work to do in figuring out how to move forward, I would focus there.
Aviva, do you want to jump in with final thoughts?
The question of what more can the law school do, or should the law school do? I think what has been neglected is poor students that come from poor neighborhoods and have had a poor education and don't do well on the LSATs, or anything that supposedly shows aptitude but doesn't really show education. I think the law student should take it upon itself to try to find these students and either either subsidize them with a year of good tutoring before they enter law school. Yeah, I don't know what else, but the measurement of standards, I think, needs to be broadened to take into account some of these students who have not had advantages of decent education.
Sharon, do you want to add some final thoughts before we give Jeff the last word?
Sure, absolutely. So I was on a panel yesterday. I attended a panel of women of color, in the profession, that were talking about some of the challenges that we all face. And someone made a comment that really resonated with me, which was, enough of the mentoring. We don't need mentors, we need sponsors. We need people out there who can actually stand up for us when the partnership decisions are being made, when the tenure decisions are being made, and can advocate for us. It's great to have somebody who you can go and bounce problems off of, but we need people who can really stand up and support us when the time is important. So I encourage all of you out there as alumni to think about that and consider how you might be part of that effort. And I also just want to thank you all, the women on this panel today. As a Black woman, I recognize that people like you who came before me paved the way, that you guys are the trailblazers that made my path easier. And I just want to thank you for that and for including me today.
Jeff, we're giving you the last word. As the only man on our panel, we're giving you the last word.
One other story about history I think I want to relate, because it always fascinated me. And it has to do with the law school's concern about diversity and giving opportunities. When I became dean in 1987, I went through the files in the dean's office, and there were all sorts of letters there from my predecessors. And I happened to come across a letter written in 1961. Robert Kennedy, who'd just been appointed Attorney General, wrote the deans of Harvard, Yale, Chicago, Stanford, and Columbia, and said to them he was really disappointed and stunned when he went to the Justice Department to discover how few African-American lawyers there were in the Department of Justice, and wrote a letter to each of the deans. At Chicago, it was then Edward Levy, asking for recommendations of particularly African-American alumni of the school who might be appropriate for working in the Justice Department. And Levy wrote back a letter in which he named 4 or 5 individuals, all of whom names I recognized and went on to have distinguished careers. But what was interesting to me and really surprising about the letter is Edward talked about the fact that the law school worked very hard to identify and to recruit minority students, to bring their perspectives to the law school and to give them the opportunities. And this was before the phrase affirmative action, for example, even existed. And it was just fascinating to see that this was something that Chicago, and I'm sure other leading law schools, was already doing before anyone was openly talking about it as a responsibility of a legal education. Looking forward, I do think that Chicago, like other leading law schools, is working very hard to address the injustices in our society and to create opportunities that otherwise might not be available to students who are particularly poor and minority. But it is a challenge because you don't want to put students into an environment where, quite frankly, they are not prepared to do the work compared to all of their all of their colleagues. So that is a fine distinction that has to be made, but it's clearly a priority that the law school should have, does have, and I think the legal profession needs to have as we move forward into the future.
Well, on behalf of everybody on our panel, I just want to thank all of you for joining us today on reunion weekend and being part of this continued dialogue about women in the law school, diversity, inclusion. I heard a great phrase this week that I'll share with you, which is we want to think about our this whole area as JEDI: justice, equity, diversity, and inclusion. And JEDI has obviously a cultural significance more broadly in the Star Wars arena, but it seems to me like a really powerful acronym for what's important: justice, equity, diversity, and inclusion. It shaped our lives at the law school and obviously is of great significance to what's going on there today. So thank you for joining us. Enjoy reunion weekend.